when you have a clinic, you have certain responsibilities. We know that. And we talked about jointly and severally or deep pockets. And I'm going to give you an example of a claim where a clinic provided tables for the RMTs. And with a rather hefty, shall we say, individual on the table and rather aggressive massage therapy techniques being used, the table collapsed. They sued the massage therapist for malpractice because they were working on the patient at the time. They sued the massage therapist for general liability because they weren't sure it would fall under malpractice, and they sued the clinic. Fortunately, everybody was insured by the same insurance company. Thank you. But let's take a situation where possibly the clinic that supplied the table did not have adequate liability insurance for the claim. And they were found, and this is what we talked about, the clinic is found to be 60% responsible because they supplied the table, didn't make sure it was safe, and the RMT was found to be 40% responsible. The clinic doesn't have any money or assets. It's the RMT's policy that will pay 100% of the claim. So having your own insurance as an RMT is great. Having it as a clinic, that whole thing could have been reversed. You know you can't have an RMT working for you that isn't with the college, and the college demands they have liability insurance, but what the college demands is a very low limit. The college also requires your RMTs working in your clinic to have malpractice insurance covering a certain amount per occurrence, but they don't say the policy has to be an occurrence policy. How many here listen to me speak at the West Coast College Massage Therapy at any time? Any of you? Okay, a couple of you. You still can't leave the room, I'm sorry. The whole thing with the occurrence policy versus the claims made policy, they both insure exactly the same thing. What makes them different is when the claim happened. With an occurrence policy, the claim is deemed to have happened when the alleged or actual injury occurred. So if I go and see somebody today and I'm injured, that's the date of the occurrence. However, I walk away and I decide I'm not going to do anything, and 2 years later I'm talking to my friendly lawyer, and they say, well, you know what? You should have gotten some money out of that. That was very, it changed your lifestyle. So 2 years down the road, or just short of 2 years, I file a claim against the RMT and the clinic. Under a claims made policy, the day I file that demand for money, that's the date of the claim. No big deal unless the RMT has retired and has not elected to maintain what's called a tail on their claims made policy. On the claims made policy, they have no insurance. Under the occurrence policy, they do. Every RMT that we insure has an occurrence policy. Every clinic that we insure has an occurrence policy. Clinics, in all the years we've been doing this, and I've been involved for over 25 years with your association, we've never seen a clinic be sued for malpractice. What we are concerned about is they're going to be sued for failure to exercise control or anything like that. That's a general liability issue with us. The issues around liability insurance are that if there's going to be an injury, it's usually going to be significant. I'll give you some other examples about insignificant ones in a moment. Malpractice is not the big issue. We've seen claims in excess of $100,000 for malpractice. Does that surprise any of you? No? Good. It shouldn't. We've seen claims, not necessarily for massage therapists, but for clinic owners in general, for general liability, for well over $500,000. What you do for malpractice, your hands-on treatment, usually does not result in the same serious claim as somebody walking through your front door and slipping on the floor and breaking a hip. That's why we combine the two, to relieve any worries that you might have. And again, that's going to be a situation for the clinic owner to make sure that they have the general liability insurance. General liability insurance, and Scott, correct me if I'm wrong, if there's a slip and fall, you're going to name as many people in that clinic as you can. Everybody. And you'll probably add Jane Doe and John Doe. And there's a reason for that. That wasn't a foolish comment that I just threw out there. We do see that your policy protects you as a clinic owner. It protects your employees, your agents, your spouse, which can also be named in certain cases. Contractors are covered under our policy. Not all policies cover contractors if they are named in a suit. The contractor may have no responsibility for what happened. They may not even be there that day. But if they're named in the suit, you want to be able to defend them for your negligence. Conversely, if the RMT does not have adequate general liability insurance and they're sued because they allowed somebody off a table who slipped in a little bit of oil, they're going to sue the clinic, the RMT, and everybody else there. And that gets back to this indemnification between the clinic owner and the RMT. And I'm sorry that it was commented that they might take that out of the agreement. Please don't. For us, that's very, very important. Does anybody have any questions about liability side of it? Oh, yes.
So a quick question. If a clinic is incorporated, how does it work with that general liability? Does the owner and the corporation have to be named in the actual liability insurance?
No. When you incorporate, as far as we're concerned, and I'm not a lawyer, I sometimes use words that have legal definitions, and I may use them slightly incorrectly, and for that I apologize. But once you are incorporated, that incorporated company becomes a legal entity. You as an individual are a legal entity as well. We cover the clinic and its owners, spouse and everybody else. Occasionally, we will get a situation where a landlord, because they have a guarantee from the owner of the company, will ask that, because they have this guarantee, that they want the owner's name and the entity's name on a certificate of insurance. We usually tell them to pound sand, but they come back and say, well, no, if you won't do it, then we're going to kick them out. But no, we don't care. We're going to defend everybody, or the insurance company is. I'm just the broker. Yeah.
So each individual person here has 5 million malpractice and 5 million general liability, right? Through their insurance, through the MTA, through Shaw Sabey, it's 5 million each. So an individual RMT has that. Should the clinic owner get more than 5 million general liability on top of what they have as an individual RMT?
How rich are they? Because it's going to cost them money, which will help me. No, even the leases that we see for large corporations now, they limit 5 million general liability at the top end, usually 2 million. And I'm not going to get into the minutia of a policy. I'll gladly discuss that with anybody at any time. But this thing runs about 160 pages, and there are many areas such as what's called tenants' legal liability, which we may adjust. But for the most part, 5 million general liability is the top end that you need. Yes?
So say your clinic is in a building, they come in through the lobby, on their way to see you, slip and fall and break your hip. Can they name you as well as the building in which you are using?
Yeah, the standard answer I give for that is that you can be sued at any time, anywhere, by anybody for any reason if they find the right lawyer. Is that a fair comment, Scott?
Sure, yeah.
I mean, that's painting you with a broad brush. And yes, they can name you, and we would defend you. And if it was found that you were somehow responsible, your insurance company is going to pay for that claim. And we do get some very far-fetched ones. I do want to touch quickly on the property side as well, if there's no other questions about liability. Property insurance, you have to be very careful. Before you sign that lease that's being written by the lawyer, please send it to us to review the insurance requirements. Insurance has a different language than the courts. So we often get a lease that comes in that says you need a certain limit of liability for personal injury. Personal injury to us is libel, slander, wrongful eviction, or unlawful detention. Where they use the term personal injury, we use the term bodily injury, and we want to make sure those things get in sync before you ever sign the lease. There's also quite often requirements in there that insurance companies will not abide by. One of the most common ones that we see is they say you must give 30 days notice of lapse of your policy. No insurance company is going to do that, and that actually has been dismissed many years ago in court because it's a contract with a specific expiry date. But there's always gray areas and changes. We just like to review that and make sure that your insurance policy is going to coincide with your lease. You don't want surprises. Yes?
If I happen to be a strata owner, does that change your comment on that?
No. No, not really. But please tell us if you're a strata owner, because there are other additions that we must make to your policy for contingent coverages. Strata ownership is different than renting or owning a building or operating out of your house. So we need to know exactly what your circumstances are. Yep.
Somebody's operating out of their house as well as a clinic. Are they covered?
We cover, on the liability side,
Yeah.
we cover you anywhere in Canada. Now, we do. There's a company out there called Trisura that is based in Ontario, that they will issue a liability policy for you, a malpractice policy, which at this point is accepted in British Columbia, not accepted in Ontario. And that's creating some issues. We cover you anywhere in Canada, period. And internationally, if you're traveling with a national team. Yeah.
So say if you are going to take a course in Austria, are you required to possibly take extra insurance then for something that may happen while you're there? Because you would be covered because you're not in Canada?
You'd have to talk to them over there. We will not cover you outside of Canada, period. And the reason being, you're not licensed. But I'm just going to give you a couple of examples of claims that have occurred. And if the claimants are here, I'm not mentioning names, so don't come after me. We had a situation at a home-based clinic where somebody received treatment and then they wandered down to the washroom and fell downstairs. Now the RMT has $5 million of general liability, but they didn't have that significant amount under their homeowner's policy. In this instance, because of where the washroom was, the fact that they had taken a break, that they sat and actually had tea together, the treatment was over, that claim fell under the homeowner's policy. You may not realize that we actually have a group plan for RMTs for homeowners insurance to make sure that that is looked after as well. We had another claim, and this goes to business interruption, where there was a fight outside of an RMT's office. One party got thrown through the window. This was in the evening. The RMT came in the next morning to find there was blood in the treatment area. They were shut down for over 2 weeks because bodily fluids have to be cleaned up in a very specific manner. We paid for the loss of business. The hydro building downtown, poison gas in the basement. Everybody shut down for a period of time. Our policy covers it. So make sure that as clinic owners, that your insurance broker informs you or will answer questions about what insurance you have. We have the broadest policies out there, but we're not. Well, actually we are usually the least expensive, mainly because of volume discounts. Any questions? Yes?
I wasn't fully clear on the occurrence policy and the claims policy. It seems, obviously, this is not very important. Could you define it a little bit better or
Yeah.
explain it?
Yeah, and I'm sorry, I glossed over that because there have been articles written about it. There's actually an article on the college's website as well. It is, if you take anything away from this today, and I mean anything, including the agreement that is drafted and everything else, this, in my opinion, is going to be the most important. I'm an RMT. I'll give you a specific example. This revolved around an RMT that we did not at the time insure, situated in Kamloops. And what happened is the RMT went away over Christmas. Her policy came up for renewal January 1st. She came back and decided she would renew it around January the 15th, whatever it was. Between January the 1st and January the 15th, she was served with a writ that she was being sued for a treatment that she had given a few months earlier. She had no insurance under a claims-made policy because a claim happened when that demand for money hit. The lawyers involved very prudently, realizing they did not have insurance, received, I believe it was an injunction that prohibited them from disposing of property, her or her husband, until it could be resolved. Under an occurrence policy, the incident happened when the treatment happened, and that RMT would have had full insurance. So claims made when the claim lands on your desk, occurrence when you had a bad treatment. Is that a little better?
A bit. It's okay. Is there a post on the DOT website?
You just go to the college website. There's an article there. There's also articles in various MTABC magazines, and come and see me afterwards. Anybody that wants clarification of that, that to me is the biggest thing that you need to know. Okay? Thank you very much. Oh, I see a question over there.
In a nutshell, you're saying make sure you have occurrences.
Oh, definitely. Definitely. And I have reason to believe that the college may be clarifying their bylaws, because there is a gray area there right now. And if they do, it'll be to go to occurrence. Yeah?
So I want to clarify that the general MTA policy is an occurrence
Yes.
policy.
Yeah, we have occurrence. Occurrence is
Yeah,
what we want.
that's you're very, I will tell you, of all the medical professions that I know, you're the only ones with an occurrence policy. My policy is claims made. Almost every lawyer that I know, their policy is claims made. Architects, engineers, dentists, doctors, they all have claims made policies because the insurance company is trying to reduce the chance that they are going to have claims pop up down the road. Yeah.
We get a lot of people asking at the MTA about the travel insurance if they need extra for any reason.
Sorry, can you speak up a bit? I'm old and deaf.
We get a lot of people asking if they need additional coverage in addition to the insurance, the travel insurance that you offer. Is that ever the case, or does that insurance include everything that they need while they're traveling anywhere?
No. No policy will cover you for everything. The policy that we have for emergency travel coverages, travel emergencies, is a very broad policy. Are there others out there that are broader? Not that I'm aware of. We don't include coverage for spouse. you have to buy that separately, or children. And it's like, no, no, no. You have a very, very broad policy. It's broader than BCAA's. It's broader than one we looked at with respect to Sun Life. And I could go on and name some others, but everything is always a balancing act. Somebody over here will give you a little benefit, but then they take away something else. Insurance is like tax, and I make no bones about it. Insurance companies are in business not to pay claims, they're in business to make money. And when they start losing money because they're paying too much in the way of claims, guess who reimburses them? All of you through your premium. So that's why I say it's like a tax, and my job is make sure you're getting the broadest possible coverage at the most reasonable premium. So speak to me afterwards about anything you want clarified. More than happy to answer. Okay, thank you.